Next week is temporary orders, right? Or is it consent, consent decree? Okay, great. Just good to know. Well, hey everybody, welcome to our Doc Prep Live today. We're going to talk about petitions for dissolution, so a very traditional divorce process. So let me see if I can share my screen. Um, okay, so the documents that you have to file are extensive. There's a lot of like repeated information, so I think we're just going to kind of go over the most substantive stuff, things that people have the most questions over today. So this is right in the middle of the documents that we're going to file. It's going to start out by asking just some information about yourself and the other party to get things started. Let's see. It's going to ask some information about your marriage here up top, when you were married and where. Some background information about the marriage, and then the court needs some information to know that they have authority to determine this dissolution and also like the type of marriage it was so that they know how to proceed. So if you have a covenant marriage, Arizona is one of like only 3 or 4 states that even has covenant marriage options. So it's a special process when you get married, you have to elect to have a covenant marriage. So if you have a covenant marriage, you'll know. And that's a different process. So we're checking these boxes here. Arizona is a no fault divorce state. So you don't have to prove any wrongdoing in the marriage. You don't have to prove like an affair. You can just have a divorce because you're asking the court to have a divorce. So you're going to check this box saying that the marriage is broken beyond repair. You've tried to resolve, and this is where we're at is for the divorce. We're going to file the dissolution in the appropriate court in the county where you live. And in Arizona, you have to have lived uh, in the state for at least 90 days so that the courts can have jurisdiction over this matter. So check the box that you or the other party have lived in Arizona for at least 90 days. This question about domestic violence is really if there's children's issues that we need to sort out. So the court has to know if there's been domestic violence, and they'll consider that um, when determining legal decision making for the children. So we'll let the court know if there's been domestic violence or not. And then it's asking for information about the children in the marriage. If you don't have any children common to the parties during the marriage, then there's actually a different form. It doesn't include this information, but for now, we'll give them some information about the children because the court is going to decide issues about the children. They're going to talk about a parenting time schedule. They'll talk about legal decision making, which is like decisions about where the child goes to school and who their doctor is and when they get their wisdom teeth out. And then the court will also determine a child support amount. So we'll give them a little bit of information about the children. Select also if you're currently pregnant, if that would be a child that is common to the parties that needs to have some authorities figured out for them. So we'll check down there. Um, let's see. And then the court is going to talk about division of properties and debts. So in Arizona, we're a community property state, which means any property that was acquired, property like homes or vehicles or retirement accounts, any kind of property or asset, businesses even, is presumptively labeled as community property. And in a divorce, the court looks at that and wants to divide those things equally. So if the property was acquired like from the date of the marriage to the date of filing the petition for dissolution, then the court will look at that as community and will want to divide it equally as possible. So you'll list some just information on properties that you have acquired in the marriage. Maybe you have a primary home and you have a cabin or some second home somewhere that you acquired during a marriage. You can list all of that. It's asking about any household items. This one trips people up a little bit because a lot of the times by the time a petition is filed, the parties are already separated, they're already living separately, they've already, taken possessions that they really want um, with to their separate places. But sometimes there's a specific property that you want included in the decree that's protective so that it gets awarded to one party or another. So like I've seen a Peloton, somebody wanted the Peloton awarded to them, or artwork, something big that you for sure want written in. This is not, you don't have to list out like every tiny little piece of furniture that you have, every fork and knife. Um, it's asking about like retirement, pension funds, 401k plans. So sometimes parties will just say each each party can keep their own um, the retirement accounts. But sometimes, I mean, this is community property, so it each party is entitled to their 50% share of the community contribution that went into the account. So let's say like a 401k existed before, and then on the date the parties were married, any contributions that went into that account and any growth on those contributions, that's presumptively community property, and the court needs to figure out some way to split that up. So sometimes there's you can do a really intensive analysis of what how what portion of those funds are community and how much each party is entitled to. That's called a quadro. But sometimes parties say, maybe the other party will keep the account and they'll pay me an equalization payment of $20,000. We're just going to call it even right there. But like I said, you can also just say each party can keep their own account. There's a lot of ways to get creative and divide these things. It's asking about vehicles. A lot of times parties just want to keep their own vehicle, have the one that they drive awarded to them, and that will come with its, if there's any uh, loans on the vehicle, you'll also be awarded that. So something to keep in mind um, about vehicles. Then it's asking about separate property. Separate property is different from community property. So separate property is like if you had property before you got married, that's separate. Like say you had an investment property that you were collecting rents on or something, and no community funds were used to like pay the mortgage on that or pay for repairs or something. If that is totally separate, that's presumptively yours, and should be, you should keep it as your sole and separate property. So if there's any items like that, or I just worked on one recently where there was a big inheritance. The wife got a big inheritance. That is, even though it was obtained during the period of the marriage, that's still presumptively separate property under Arizona law. So any of those things you can list here. And then community debts, same kind of concept as community property. If it was incurred during the period of the marriage, that's presumptively community and should be split evenly. So the idea behind that is like if there's big credit card um, debts that exist, the idea is whatever that was spent on was spent to benefit the marriage, and so that those kind of debts will be split um, evenly. Sometimes you can make an argument that those funds were not used to benefit the marriage. There was waste. So that's something that you can definitely assert, but uh, the forms right here are asking for community debts, or like maybe the parties took out student loans during the marriage. Those should be divided somehow. A lot of times parties say that they'll just keep their own. I've seen that a lot.
They
And
are
then,
they are presumptively community. So there's a
right.
lot of misconceptions about student loans because they usually end up going to the person who took out the loan.
Hmm.
But they are community. So it is definitely something that can be negotiated or argued about.
Yeah, absolutely. Um, just, yeah, if you, don't want to be, I mean, you can divide them in any way that you want. And most of the time,
Hmm.
in my experience, the people just want to keep their own.
Hmm.
But you're absolutely right. It is subject to division if that's something that is worth arguing about.
Hmm.
Yeah. Um, Tax returns, pay attention to this. This can have some longer implications, but most of the time, parties will say that they're going to file jointly in the year previous that they were married, and then ongoing they'll start filing separately. But might be worth talking to a lawyer or a tax person if you have assets that you're concerned about. The court is also going to come up with some award for spousal maintenance. So, spousal maintenance is a two-part determination. You first have to qualify for, be eligible for an award of spousal maintenance. So that's what these boxes are. You're telling the court the reason that you should be eligible um, for an award of spousal maintenance. And then part two is the court will determine the amount and the length, like how many months that amount should be paid to you. So the idea with spousal maintenance, it doesn't last forever usually. Um, the idea is that the party receiving spousal maintenance can get back on their feet. They can get some training or education. Maybe they haven't worked in 15 years during the marriage. So the idea is to support them until they can become self-sustaining. So these awards, they don't last forever, and you do have to qualify in some way for them. So that's one that we just talked about, was they lack earning ability in the labor market, maybe because their marriage was super, super long and they stayed at home taking care of kids. So now they need to get some new training, new job experience so that they can provide for themselves. Then the court's asking for, if you have like a prenup that they should look at. Maybe you've already decided how to divide things. Everything else on these forms is like a lot of, oh no, here we go. There's still more. Domestic violence. The court needs to know this. We talked about this. Uh, they'll consider incidences of domestic violence when they determine child custody issues. Same thing with the drug and alcohol convictions. We should tell the court that so that the court will know how to award like parenting time and decision making for the children. And then child support. um,
Can
child
I
support,
stop you
we,
for just a quick minute?
yeah, yeah,
Can we talk about this domestic violence section? Because
sure.
it comes up a lot, and I spend a lot of time talking with my clients about this because it's not defined here in this petition. It is defined in the family law statutes, and one person's definition of domestic violence is not another person's definition of a domestic violence. Or people will feel like, yes, there was domestic violence, but I don't want to write that. I don't want to write that. And the thing is, that's okay, but you can't really change your mind later.
Mm.
So it's a really important conversation to have. If you don't want to bring in the legal presumption that applies if you can prove domestic violence happens, many times I agree with you, and that is a good idea. Because the domestic violence that we're talking about, again, people's definitions are different. People could say that there was this time when we were in a fight and she took my phone and wouldn't let me leave. And that could be domestic violence, or, it just could be so many things. So part of the discussion is, do you want sole legal decision making? Because what domestic violence really impacts is legal decision making and parenting time. So do you already have agreements on decision making and parenting time? Are you able to make decisions together? Do you want to make decisions together? If you are in a place now as a couple where, yeah, you don't have any problem making decisions together, you guys are doing 50-50, yes, there was domestic violence, but you don't want to write it down, that's probably okay. Because writing that down and serving someone with it can certainly have consequences.
Yeah, yeah, absolutely. And you make a good point too about sometimes even if well, you should preserve the claim usually because it's hard to go back and
You
fix.
can't go back. So don't tell me everything's good right now. I don't want to write it down. I think everything's going to be okay. And then proceed to tell me this like horrific last 10 years of your relationship where you're married to somebody who's pretty dangerous and you're really just scared. That we can't do. So we really have to have a conversation about this and analyze the consequences of this and what happened and what does the future look like. And many times, Paige, we can predict what will the difficulties be between this couple by really looking at what their relationship pattern has been up until this point. So we can help them determine, will joint legal decision making and equal parenting work? Do you really need some supervised parenting time in place in order to protect your kids? And if you do, then we have to check the box, even if it's uncomfortable.
Right. Yeah. And that's what people get hesitant on is this just going to open up a bigger can of worms, if I do assert it right now. So, yeah. And if there's a history, like you say, of not being able to communicate between the parties, that's for sure something to talk about. Yeah, that's a great point. Let's see. Yep. And then the last thing is the court's going to look at child support. So we've talked in past weeks on how to fill out a child support calculator and some of those issues. But really, Billy, the big things that the court is looking at in a dissolution, 6 or maybe 7 things, is child parenting time, legal decision making for the children, and child support. They're going to look at spousal maintenance, if that is applicable here. They look at property and asset division of debts, and then sometimes there's talk about attorney's fees if one party is being unreasonable, for example. But yeah, those are the major issues that courts look at in a dissolution.
Wonderful. Okay, well, we have some questions here. All right, here's one that came in. We have 2 kids and my spouse already filed a separate custody case. Do I need to include the custody information in my petition for dissolution? We have 2 kids. My spouse already filed a separate custody case. I'm confused.
Yeah, that's a tough one.
Did your husband file for divorce already? In which case you need to file a response or
Mhm.
yeah.
Yeah. Yeah, I mean, if there are other, like sometimes child support can be um awarded and in a separate matter and you want to bring the two together, but I don't know, it's unclear if they're
Yeah.
married or yeah, I'm not sure about
Go
that
on to the
question.
next question.
All right,
My
moving on.
spouse has a retirement account, but I'm not sure I'm entitled to any of it. Should I mention it in the petition or does that come up later in the process?
Definitely mention it in the petition. It's okay if you don't have all of the information about it right now, like how much is in it, that can be determined later. And like I kind of briefly mentioned, the quadros, sometimes they have to really go in and do a deep accounting dive to figure out what portion is yours.
Mm-hmm.
But yeah, definitely bring it up. You are entitled to some portion of that if contributions were made during the marriage.
Mm-hmm. Okay, here's another really good question. My wife and I have already been separated for 4 months. She is now pregnant and we're filing for divorce. The pregnancy is not mine. Do I need to mention the pregnancy in the petition or do we wait until the baby is born?
Definitely mention that the party is pregnant, and then there's going to be an issue of determining paternity. So if the baby's born during the marriage, that will presumptively be you'll be the presumptively the biological parent. But that can be overcome if you can, prove somebody else wants to sign an affidavit of paternity or prove in some other way, DNA test.
Yeah.
That
And
can
you
be
can
overcome.
almost
But
use this divorce process as a way to get a order of non-paternity. So you can say in the petition, yes, wife is pregnant. However, the parties have been separated and understand that the husband is not the father. And then when you get your decree, it can say, wife is pregnant or wife has another child not of this marriage. And then you're legally dealing with that presumption that you have that married people automatically have paternity ascribed to
Mhm,
them.
mhm.
Next question. We own a house together, but my wife wants to stay in it after the divorce. Do I include anything about the house in the petition or do we handle that separately?
Yeah, definitely include it in the petition. One thing that might be good here is to get some temporary orders in place. So if she wants to stay there, can be awarded use of the residence, and to pay like all the expenses for that maybe. But you do have an interest in the properties, so definitely allege it in the petition.
Yeah, and what about cases where couples already have some agreements and then they have some issues they disagree on? What can they do about that?
Yeah, I mean, if you have agreements, that's great. You can let the court know of your agreements and get that out of the way. We don't have to, argue about those in court.
Yeah, that written agreement section that it asks about in that form, that doesn't have to just be prenups and postnups. That can be, yes, we have written agreements regarding this. And what'll happen is that written agreement can turn into a binding Rule 69 agreement. So you can lock down those issues. So, for instance, if you know that your wife is staying in the house, I want you first to think about, well, how are you getting your share of equity out of the house? And also, we look at tax affected values when determining who's getting what in a divorce. But once you work out all those details, let's say you feel super good about that, lock down any agreements you have as soon as you possibly can, which might include during that petition, which is a great way to make things simpler. All right, another question. I've been living out of state for the past few months. Can I still file the petition in Arizona if my spouse and kids are there?
Yeah, especially if the kids are there. Arizona needs to retain jurisdiction over the kids. So, yep, Arizona is the spot.
My spouse and I have been separated for over a year, but he refuses to sign anything. Can I file the petition without his agreement?
Yeah, you can definitely file. And it sounds like if he's not willing to sign, he's not going to respond in any way. Eventually, you might go through the default process. So if he's not going to respond or participate, um, you, after a waiting period, can apply for default and get the divorce decree anyway, even though he's not participating. It's just a little bit more of a process.
Yeah, we got some hoops to jump through
Yeah.
because divorce is a big deal, but yes. Okay, my husband and I have no kids. We have very few assets. Do I still have to fill out all of the financial sections of that petition?
Yeah, still fill out the petition, but it sounds like if there's not that much to divide, maybe a consent decree is a better way to go for you. That's a consent decree. We're going to talk about it in future weeks, actually, but that's if you can agree about dividing everything. It's a little bit of a different process to get a divorce. But that I think would probably be a good format if there's not that much to divide.
Yeah, I love the walkaway divorce. I think if you can and if it's close, you're better off doing the walkaway divorce than taking the time to go through the, dollars and cents. That's just me because there's so much time and money lost in determining those details. Like if you can just say, I'm going to take my credit cards, you take your credit cards, this is my car, this is your
Hmm.
car. Quicker to that fresh start,
Yeah, absolutely.
All right, let's see what else we got. I have been the primary caregiver for our kids, but I work full time. Should I ask for sole legal decision making in the petition, or will that seem too aggressive?
Yeah, so legal decision making is tough to come by. Usually there is like incidents of neglect or abuse or something. So that is a big ask to go for sole legal decision making.
Yeah.
Um,
Do you
Go
have
ahead.
that agreement? Do you and your spouse agree that you can have sole legal decision making? Because if the only reason that you think you should have it is because you've been the primary caregiver, unfortunately, that while it makes perfect sense in your home, this is how you divided those duties. Like a court isn't really interested in what has happened up until now. That can be a tough pill to swallow.
Yeah, that's a frustrating thing I find for a lot of parties is the other party isn't, they have joint legal uh, or even final say, and the other party just doesn't want to participate. That's super frustrating. And you're like, why wouldn't I just ask for more anyway?
Right. Yeah. Why should I have to have joint if I've done it or I'm just going to get blocked at every turn from the
Mhm.
decisions? Yeah, it's definitely, I think, frustrating.
Yeah, that's a toughie.
I think that my spouse may have been hiding money in a separate account. Do I include this in the petition? How do I find the information? And when do I bring it up?
Yeah, that's a tough. You can, if you suspect that, I'm sure you can write it in the petition. Then there's a period of disclosure and discovery where um, they will have to provide financial information like that, bank account information, and you can make requests for like that specific account if you think that it's out there. So eventually it should come to light, and if it doesn't, if they really are trying that hard to hide it, that's going to be trouble for them.
Yeah. Yeah. So often, this is a discussion we have with people where they might think that somebody's hiding money, and we have to really figure out, well, why do you think that? You know? And if all the money that you guys have been making is W-2 income and you've been spending essentially as much as you've been making, there's probably not hidden money out there. And we could spend a lot of money subpoenaing every institution looking for hidden money, but it is likely not worth it. And there's usually a trail, right? There's usually money transferred to an account ending in blah, 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 blah. That's usually how we find hidden assets. If they are really good in hidden, different properties in different states, the only way to find that is to literally look in every single county of every single state. And then you don't know if somebody is owning property in an LLC that they created, or like it's tough. So I like to start with the income side. How much money is coming in, and do we know where that went before I start looking for hidden assets?
Hmm. Yeah, math adds up usually in the end.
It does. Math adds up. Let's see. We may not have any other questions. Um, One, there's no more questions that we have for viewers, and we just have a few minutes left. But one thing that I see people struggle with is, what if I don't have all of the information right now and I want to file for divorce? Can I still file this paperwork if I don't have all this information?
For sure, for sure. Yeah, these initial documents just get the matter started. And then there's that period of disclosure and discovery where you provide to the other party and they provide to you this information. And that a lot of times can help you come to agreements. You can see what you're actually dealing with and decide how you want to proceed. If it's something that is you can agree on, if it's minor enough, or you're willing enough to agree on things, then that's it. The period before the hearing is a good time to do that, and lessens the issues that you're going to talk about at the hearing. So
Mhm.
yeah, there's lots of time to get that information, and hopefully that helps you have a clearer picture of what the outcome that you want to see.
Absolutely. We, as lawyers, typically file pretty vague petitions. Equitable division of community property. That's what we're
Yeah.
asking for. Not you get this, I get this. That's usually what we ask for. Now, if you are representing yourself and you are looking, you think you might have to file for a default, they may not answer, then that approach, that general approach, will not work. You have to tell the court specifically what you want in order to get a default decree giving you what you asked for. But so that's one of the some of the analysis you need to do is what is the likely trajectory of my divorce? Is my spouse going to answer? Am I going to be able to find them? Am I going to need to serve them via publication? In which case, we have to be as specific as, what are you asking the court to do specifically? Because you can't go ask the court to give you something specifically that you haven't written down in your petition. But if you know you're going to go through disclosure and discovery, nobody's going anywhere, we just have the business of the divorce to work out, then there's nothing wrong with having a very vague divorce petition.
Yeah, that definitely um, helps parties be willing to go proceed with the divorce, because you don't ever have like all the information right up front. So that would be such a hindrance to file anything if you had to have all the information right up front.
Absolutely. Yeah. Yeah. And the reason that we lawyers write it vague is because we want the ability to adapt and change our
Right.
mind and ask for different things.
Yeah.
It's that, we were talking about the domestic violence thing, like, we want to leave our strategy open-ish, for what we discover. So
Yep.
anyway, thank you so much, Paige. I appreciate you. It was good to see you today. And thank you everyone so much in the Modern Divorce Support Group. We are so grateful for our online community and the constant support that you give Modern Law and the constant shout outs that you give Modern Law and all of your referrals that you're doing online. We see all of that. And I just want you to know how grateful we are for you, for that community.
Good to see you. Thanks, everybody.
Bye.